Swayam Prabha. Digital India. Educated India.
Hello viewers, I am Dr. Saurabh Rana from Faculty of Law, University of Delhi, and I, along with Professor Dr. Vageshwari Deshwal, Faculty of Law, University of Delhi, would be discussing procedural criminal law, which is contained in Bharatiya Nagrik Suraksha Sanhita 2023. This is session 17, and today we would discuss appeal, reference and revision. Now you see, every effort, every safeguard is taken to ensure a fair trial, both to accused as well as victim of the crime. But then human are fallible and the mistakes are bound to occur. So the criminal procedure provides for redressal mechanism to rectify those mistakes. So appeal and revision are such redressal mechanism where such mistakes can be rectified. A reference is a mechanism where such mistakes are prevented from happening. So here a lower court would raise a question to a higher court and seek clarification so that it would decide in accordance with law. So that is reference. We will see them in detail in this session. Now first let us start with appeals. This is chapter 31, BNSS 2023. And the first provision says that section 413 says that no appeal shall lie from any judgment or order of a criminal court except as provided by this Sanhita or by any other law for the time being in force. Now the idea propagated by this provision is that appeal is not an inherent right. It is not an inherent or a natural right for either of the parties, state as well as accused. Appeal lies only when it is provided. So that is the idea of this provision. But when it is provided, when appeal is provided, it is a full extension. It is deemed to be a full extension of trial. So not only the facts may be reopened, evidence may be reappreciated, but of course also it may be held on points of law. So both on facts and law that the appellate court may go into, we'll see later that not all redressal mechanism can do that. Not all redressal mechanism may do that. Say for example, revision, the court cannot go into resettling the facts. Generally speaking, in revision, the facts are not resettled, unless of course in certain circumstances where the facts may be touched upon. That we'll see later. So the idea is that appeal would lie only when provided by law. It is not an inherent or natural right of any party, state, victim or accused. When it is provided by law, then it is a full extension of trial. So that may amount to, it may safely be said that it would be a kind of re-trial in a restricted sense. Restricted because witnesses need not to be recalled again unless required. But then yes, appreciation of evidence can be done and facts may be resettled. So suppose on a particular set of evidence, the trial court said or trial court reached to the finding that A was at a railway platform at 10 a.m. Now this fact, once settled by trial court, may be resettled or may be interfered with by the appellate court. So the court may actually go into the question whether A was there at 10 a.m. at that particular railway platform or not. And for that purpose, the appellate court may reappreciate the evidence. And of course, on point of law also, the court may scrutinize the case. Then it says, provided that the victim shall have a right to prefer an appeal. Now, you see, the word victim is used here. It should be seen in contrast to state or the public prosecutor. So, generally, these are the functionaries who would be filing appeal, say against acquittal of accused or say inadequacy of sentence, etc. But then this provision, section 413, gives victim also a right to prefer an appeal against any order passed by the court. Number one, acquitting the accused. So in these circumstances only that the victim shall have a right to appeal and not in other circumstances. So number one, that the accused was acquitted. Number two, that he was convicted for a lesser offence. For example, somebody was charged under section 302, old BNS, old IPC 302 and convicted under section 304, old IPC, then it is a conviction for a lesser offence and hence the victim may go in appeal against that, or imposing inadequate compensation. And if the victim thinks that the compensation is inadequate, then it may go against that also. And then it says, and such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction. We'll see it later. Now, if you see these three ideas, acquitting the accused, convicting for a lesser offence, or imposing inadequate compensation. Now, one thing is missing here, which is inadequacy of sentence. If we see further provisions, then we would come to know, as we are going to see, we would come to know that inadequacy of sentence is also a ground for appeal for state, but then this ground has not been given to the victim. So, if the victim feels that the accused has been granted inadequate sentence, he cannot move under section 413 proviso for preferring an appeal, but then state of course may move to appeal under section 418. Now, With that, let us move to the next provision, which is appeals from certain orders under Chapter 9. Now, this section says any person who has been ordered under Section 136. Now, Section 136 orders deal with Section 126, 127, 128 and 129 BNSS, and they all deal with requiring a person to furnish bonds that we have already discussed in a session for keeping peace, good behavior. Now, if somebody has been ordered, and these all are by executive magistrate, SDM, DM, etc. in general parlance. So, if somebody has been ordered by executive magistrate under Section 126, 7, 8, 9 to give security for keeping peace, good behavior, or who is aggrieved by an order refusing to accept or rejecting a surety under Section 140. This section is also under Chapter 9, as in we would be, all these provisions are under Chapter 9. These provisions are also under Chapter 9. So, here also we are talking about these sections, and it says that when somebody, now in a given case, if somebody is asked to furnish bonds, personal bond and surety bond, and now somebody comes with a surety and the court refuses to accept that surety or reject a surety. Rejecting surety is that earlier surety A was accepted, but then now the court desires to reject that surety. So, once a surety has been accepted, they would be recalled and the proceeding shall be taken to reject that surety. So, in both cases, the person may appeal against such order to the court of session. Now, the next provision is appeals from convictions, and this is Section 415. Now, it says any person convicted on a trial held by a high court in its extraordinary original criminal jurisdiction may appeal to the Supreme Court. Now, we have already discussed in another session that High Court would have original criminal jurisdiction. That means it can try a criminal case. That is the purport of Section 21 BNSS. It says that the High Court may try a criminal case as an original criminal jurisdiction. But then, as we have already discussed, and you see, if we see the procedural criminal law of the earlier times, Bombay High Court, Madras High Court and Calcutta High Court were given this original jurisdiction in criminal cases, but then this was omitted, but then the reference to the High Court has been retained in modern law also, but then such possibility or such occurrence is rare that the High Court would take up a case in the first instance and would try it. That is why it is shown here to be extraordinary original criminal jurisdiction. If you look at Section 407 of the old CRPC, there also we may find such situation where High Court may take up a case from any lower court and try it. So, there also we find this spirit, High Court trying a case as a court of first instance. So, if somebody is convicted on a trial held by High Court in its extraordinary original criminal jurisdiction, he may go to Supreme Court for appeal. Then it says any person, if he is convicted on a trial held by session judge or an additional session judge, we have already discussed that under section 22-23, they have the same competency of passing sentences. Though session judge is senior to additional session judge in administrative capacity, but then as far as passing sentences competence is concerned, they both stand on the same footing. So if a person is convicted by session judge or additional session judge or on a trial held by any other court, now here any other court means magistrate court, magistrate as in judicial magistrate court, because only judicial magistrate can convict. Conviction is no business of executive magistrate. So if that is the situation, by any other court or by session court, any other court means judicial magistrate court, in which a sentence of imprisonment for more than 7 years has been passed, then he may go to the High Court and prefer an appeal. Now, in relation to 2, clause 3 says that any person who is convicted on a trial held by magistrate first class or of second class or sentenced under section 364. Section 364 is when a magistrate finding it that the punishment which the accused deserves, that he would not be competent to pass such sentence, that is, the accused deserves a more severe punishment, severe sentence than the magistrate first class would himself pass, then he would send the case to a higher court for passing of that sentence. So, and there he is sentenced, higher court sentenced such person, such accused. So, that is the case that is contemplated here. And then it says, in respect of whom an order has been made or a sentence has been passed under section 401. Order has been made or a sentence has been passed under section 401. 401 speaks about releasing somebody on probation or after due admonition. If that is done, then it says such a person may appeal to the court of session. So, if the conviction is by High Court, then he would go to Supreme Court. If the conviction is by a session judge or additional session judge, whatsoever the sentence may be, he shall go to the High Court. If the trial held by magistrate court and the sentence is more than 7 years, then again he would go to the High Court. And finally, if the conviction is by a magistrate first class or second class or by a higher court under section 364 or again by a court under section 401 releasing on probation or after due admonition, then he may go to, when such order is passed by a magistrate court under section 401, then again in these cases he would go to the court of session. So, you see here Supreme Court is contemplated, in 2 High Court is contemplated, and in 3 Court of Session is contemplated as the appellate court. And the common idea is that they are going against convictions. The appellant is going against the conviction. Then it says, when an appeal has been filed against a sentence under these sections, these are sections dealing with sexual offences, and it provides a time frame within which the appeal should be disposed of, 6 months from the date of filing of such appeal. Now, let us look at section 418. It says that the state government may, in any case of conviction, so it is actually by state government, appeal by state government and against sentence. So, inadequacy of sentence may well be taken here. Inadequacy of sentence may well be taken up here. And it says, save as otherwise provided in subsection 2, the state government may, in any case of conviction, on a trial held by any court other than a high court. Any court other than a high court is what? Judicial Magistrate Court and Court of Sessions. Direct the PP to present an appeal against the sentence on the ground of its inadequacy. Then it says, now to which court to go? The conviction sentence has been passed by any court other than a high court. That means judicial magistrate or court of session. And now we are looking at the court to which the appeal should be preferred. So it says to the court of session if the sentence was passed by magistrate court. So if this is the case, the appellate court would be court of session. To the high court if the sentence is passed by any other court, and any other court means now court of session. That is the remaining court. So the idea would be that these would be the appellate courts, and as per the sentence passed by the court magistrate, the appeal will go to session, and any other court that leaves only the court of session, then the appeal would go to the high court. Then 2 says, now that it says here save as otherwise provided in subsection 2, the state government. Now 2 says that if such case was investigated by an agency empowered to make investigation under any central act, then the central government may also direct the PP to present an appeal. So say for example, a case investigated by CBI, then the central government also may direct the PP to file an appeal against the sentence on the ground of its inadequacy, again in the same manner, to the court of session if the sentence is passed by magistrate, to the high court if the sentence is passed by any other court means here court of session. Then it says, when an appeal has been filed against the sentence on the ground of inadequacy, whatever the appellate court is, session or the high court, shall not enhance the sentence except after giving to the accused a reasonable opportunity of showing cause against such enhancement. So that is what we know as odi alterum partem. That rule has been imported here in all fairness, that the other party must also be heard. And then it adds to it that while showing cause, so the accused has also been called and asked as in why the sentence should not be increased. Now it has been added here that while showing cause, the accused may plead for his acquittal or for the reduction of the sentence. So he cannot be silenced if coming in the court he would say that I deserve acquittal or I deserve a lesser sentence. And again, clause 4 says that in these offences, the appeal must be disposed of within a period of 6 months. Again, these are BNS offences of sexual nature. The next provision is section 419. It says, again, save as otherwise provided in subsection 2 and subject to provision of 3 and 5. Okay. Now it says, if you see, this is an appeal in case of acquittal. So wherever acquittal happens, the appeals may be brought in this manner, that is section 419. Section 419, 1A says that the district magistrate direct the PP present an appeal to the court of session from an order of acquittal passed by a magistrate in respect of cognizable and non-bailable offence. Then it says, the state government may in any case direct the PP to present an appeal to the High Court from an original or appellate order of acquittal passed by any court other than a High Court. Again, it is JM or Court of Session, not being an order under clause A. So, it has been ruled out that the case would be this, as in that it would be a magistrate acquittal in respect of a cognizable and non-bailable offence, not being an order under clause A, or an order of acquittal passed by the Court of Session in revision. Barring these two possibilities, one, that it must not be an order under clause A, two, that it must not be an order of acquittal passed by Court of Session in revision. Barring these two possibilities, it says that the state government then, in any remaining cases, direct the PP to present up an appeal to the High Court. Barring these two cases, in any case, the state government may do so. Then 2 says, again as we have seen earlier, that if the case was investigated by an agency empowered to make investigation under any central act, so say for example, the case has been investigated by CBI, then central government may also direct the PP to present an appeal, again in this manner. Now, section 419 further provides that no appeal to the High Court. Now, we have seen 1 and 2 both contemplate appeal to Court of Session as well as appeal to High Court. Now, if it is to High Court, then it must be with the leave of the High Court. So, the permission of the High Court must first be obtained, and then the appeal would be taken up in the High Court. Then it says, if such an order of acquittal is passed in any case instituted a complaint and the High Court grants special leave to appeal from the order of acquittal, the complainant may present such an appeal to the court. Now, it says that if in any case instituted upon complaint. So, we will see in a separate session that a case can not only be instituted on a police report, that is challan, charge sheet, etc., but also that it can be instituted upon a private complaint straight to the court, that we will see later. But if that is the case, then this provision says that if the order of acquittal is passed in such a case, so if the accused is acquitted in such a case and the High Court, on an application made to it by the complainant in this behalf, grants special leave to appeal from the order of acquittal, the complainant may also present an appeal to the High Court. Now, in 1 and 2, we were contemplating only the state government and the central government. Here, we are contemplating complainant also. Complainant only when the case is instituted upon complaint, not otherwise. A private person has not been given jurisdiction or not been empowered, entitled to file an appeal against the cases of acquittal, except here. Then it says, no application under subsection 4 for the grant of special leave to appeal from an order of acquittal shall be entertained after the expiry of 6 months, where the complainant is a public servant, and 60 days in every other case, computed from the order of acquittal. So, 5 provides limitation period for 4. Six months if the complainant is a public servant, 60 days in every other case, that is where the complainant is a private person. And then it says, in any case, the application under subsection 4, again we are contemplating this case, complainant filing appeal for the grant of special leave to appeal. If it is refused, no appeal from that order of acquittal shall lie under subsection 1 or under subsection 2. So, that makes it clear that if in a complaint case, this kind of private appeal by the complainant has been refused, then state government or central government may not use the provisions of 419(1) or 2. So that would be the end of the matter in a complaint case. Now let us quickly move to other provisions. It says, then it again is appeal against conviction by High Court in certain cases. So it is a specific idea that we are dealing with here. It is conviction by High Court and in certain cases. It says section 420, where the High Court on appeal reversed an order of acquittal of an accused person and convicted him and sentenced him to death, LI, or for a term of 10 years or more. So suppose, so here what is contemplated, that somebody was acquitted by the trial court, then he was on appeal. The High Court not only reversed the order of acquittal, but sentenced him, convicted him and sentenced him to death or to life imprisonment or to a term of 10 years or more. Then he may appeal to the Supreme Court. Then special right of appeal in certain cases, again some specific cases have been contemplated here. It says section 421, notwithstanding anything in this chapter, when more persons than one are convicted in one trial and an appealable judgment or order has been passed in respect of any of such person, all, if that is the situation, then all of them or any permutation combination of them, they shall have a right of appeal. So any of them can appeal and they were tried at one trial, convicted in one trial, then all of them shall have a right of appeal. Now let us go back, now that we have seen where and when appeal would lie. Now let us see where the appeal does not lie. There would not be an appeal, and it has been given specifically that in such cases there would be no appeal. No appeal. So it says no appeal in certain cases when accused pleads guilty. So at the stage of framing of charge, when charge is framed against the accused would be asked whether you plead guilty. Question, answer, and then the accused would write yes or no. If he writes yes, as in if he pleads guilty, then it says where an accused pleads guilty and has been convicted on such plea. It is not that he is tried and convicted, but he is convicted on the basis of this plead guilty. I mean, if he is tried and convicted, this section would not apply. But if he pleads guilty and convicted, this section will apply. Then there shall be no appeal if this thing happens in a high court, that he pleads guilty in a high court and he is convicted upon thereupon, or if the conviction is by a court of session or a magistrate first class, second class, except as to the extent or legality of the sentence. Not even to the extent and legality of sentence, not even on that basis. But if the conviction is by a court of session or a magistrate first, second class, then the appeal shall not lie against the conviction, but it may lie upon the extent or legality of the sentence. The idea here is that by pleading guilty, but then he does not bind himself as to the quantum of sentence, as to what sentence should be given to him or whether any sentence should be passed upon him, whether any particular sentence. Quantum of sentence and whether an extent of sentence. So suppose somebody pleads guilty, he is awarded imprisonment for say 6 months and he thinks it is too much, then it is extent of sentence. and if suppose the offence for which he was convicted is punishable with say fine only, and he has been sent behind bar for say suppose 2 months, then he would go after the legality of sentence, right? So the idea is that he cannot go behind the conviction, but then he can go behind the quantum of sentence. Of course, the sentence was otherwise legal, but then he objects to the quantum of sentence or the legality of sentence as to the sentence itself should not to have been provided, that is not envisaged by law, as we discussed. That is legality of sentence. Now quickly moving on to the next slide, no appeal in petty cases. It says, notwithstanding 415, there shall be no appeal by a convicted person in any of the following cases, namely. And if you come back here, if the conviction is by a high court, then it is considered that the high court would not commit any error. I mean, high court being a higher court, higher responsible constitutional court, that it would not commit a mistake. It is assumed that it does not commit mistake in the extent or as to the legality of sentence. So, conviction he accepts, extent or legality, the high court would not err in that. Now, coming to the next provision, section 417 says that there shall be no appeal by a convicted person in following cases: if high court only passes sentence for term not exceeding 3 months, court of session passes of fine not exceeding 1000 rupees, session court passes only a term not exceeding 3 months, fine not exceeding 200 rupees, magistrate first class passes only a sentence of fine not exceeding 100 rupees, or where a case is tried summarily, we would see what summary trial means in a separate session, passes only a sentence of fine not exceeding 200 rupees. So, you see, for high court it is 3 months or 1000 rupees or both. For court of session it is 3 months again 200 rupees fine or both. For a magistrate first class it is 100 rupees fine, and in a summary trial it is 200 rupees, that there shall not be any appeal by a convicted person. That in such cases, if the sentences are such, then convicted person cannot file an appeal. Then it says, provided that an appeal may be brought if any other punishment is combined with it as in these punishments. If any other punishment is combined with the punishments contemplated here, then the appeal may be preferred, but such sentence shall not be appealable merely on the ground. So, this addition will not be appealable merely on the ground that such person is ordered to furnish security to keep the peace. That we have already discussed, as in how do we contemplate that situation when somebody is asked to furnish bond, chapter 9. So, if along with sentence section, what section? 125. At the time of sentence, that the court may ask somebody to furnish bond for keeping peace. So, if that happens, that would not generate a right of appeal if the case otherwise falls in this category. Then it says that a direction for imprisonment in default of payment of fine is included in the sentence. Of course, if imprisonment in default has been provided, it will not make imprisonment in default of payment of fine has been mentioned in the order, then it would not make the order appealable. And then it says, if more than one sentence of fine is passed in a single case, then if the total amount of fine does not exceed the amount hereinbefore specified, that is these amounts, there shall be no appeal. Now, section 423 provides about the petition of appeal. 424 says about the summary disposal of appeal, and those appeals which are not summarily dismissed have been contemplated here, and then it gives the powers of an appellate court, and here we would see that, and here we will see the powers of appellate court. Section 427 continues. Here we see that pending the appeal, the appellate court may suspend the sentence and may release the appellant on bail. So, that is also possible. The appellate court may take further evidence. So, not only that the court may reappreciate evidence, but also may take further evidence that supports the spirit of it being an extension of, kind of an extension of the trial. Then it says about abatement of appeal shall finally abate on the death of the accused. Now, let us quickly come to reference. Reference, as I said, is that a lower court sends a question to the higher court and seeks clarification so that mistakes are not committed. Section 436 says any court that is satisfied that a case pending before, this must be there. The question must not be hypothetical. Hypothetical questions are not allowed to be raised. So, if there is a real case pending before a court and it involves a question as to the validity of any act, etc., the determination of which is necessary for the disposal of the case. So, not only there must be a real case, but that the question must be necessary for the disposal of the case, and this question must relate to the validity of any act, ordinance or regulation. And the court is of the opinion that such act, ordinance, regulation, etc. is invalid or inoperative. So, real case, necessary for disposal of the case, question about the invalidity or its inoperability or its invalidity or inoperativity, but that it has not so declared by the High Court or by the Supreme Court. In that case, the court shall state a case setting its own opinion upon that and the reasons thereof and refer the same for the decision of the High Court. References are made to the High Court. So, that is for any court. Then for a court of session, so it may include a judicial magistrate court, it may include a session court. Now, when a court of session only is contemplated, it may send to the High Court, in any case pending before it, of course, that any question of law, it may send any question of law arising in the hearing of such case. So, it need not to be this here. The law says that any question of law, if the court of session may think fit, send to the High Court. And then it says when a question has so been referred, High Court shall pass such order as thinks fit, shall cause a copy of such order to be sent to the court back to the same court. Now, let us quickly see revision. This is chapter 32. Again a corrective measure, but in a restricted sense. Not a retrial. It does not amount to retrial. So, facts won't be resettled as a matter of right or routine. Though the facts may be interfered with if there has been a miscarriage of justice. Miscarriage of justice. Say for example, evidence not considered or inadmissible evidence considered, etc. So, it is not a matter of appreciation that the evidence would have been appreciated in a certain way, but it has been appreciated in some other way. That is not the idea involved here, but the idea involved here is that it has been a gross miscarriage of justice, that evidence was totally not been considered or some inadmissible evidence considered and a finding of fact arrived thereupon. Such finding of fact which is upon such procedural gross violation would be redressed in a revision petition. Otherwise, when appreciation of evidence is concerned, then the revision would not be the right forum. Section 438, calling for records to exercise powers of revision. High Court or any session judge may call for and examine the record of any proceeding before any inferior criminal court situated within its local jurisdiction, and it may check its correctness, legality, propriety of any finding, sentence or order recorded or passed, and as to the regularity of such inferior court proceeding. Explanation: all magistrate, executive, judicial would be deemed to be inferior, so will be going to High Court or Session Court against their order or against their finding, sentence or order, and would be filing revision against their orders. Then clause 2 says that revision shall not be exercised in case of interlocutory order. Interlocutory order are such which have no significance except that they aid in proceedings. They are procedural orders. They do not decide the substantive rights of the parties. They are merely procedural. For example, order of adjournment, order of committing somebody to court of session, etc. So, in those cases, the revision application will not be filed. And then it says, if an application made to the High Court, then no further application by same person to the Session Court or vice versa. So, if somebody files a revision application before Session Court, he cannot then go to the High Court for revision. Power to order inquiry. This is a narrow idea where when examining record, three things are found: discharge, that somebody has been discharged, or discharge as in at the stage of framing of charge. We will discuss that later in a separate session. So, somebody discharged, somebody against whom a complaint is dismissed. So, A made a complaint against B and that complaint is dismissed by the court under old section 203, or where the complainant fails in submitting process fee. So, this is where the complaint is dismissed. This is when the process fee has not been, process fee for issuing process has not been filed and the summons could not be issued for the accused person. Then in these cases, it says that if High Court or Session Court finds that these are the cases, then they would ask a Chief Judicial Magistrate to make a further inquiry into the matter, and then only that they would further proceed. The reason is that when these things are done, somebody discharged, complaint is dismissed against somebody, or if somebody does not file process fees, then the matters are not considered to be such that the High Court or Court of Session would straight away take them. So, as a matter of primary scrutiny, that the CJM would be asked to make a further inquiry into the matter, and if then they deem fit, then they would take it up. High Court's power of revision have been given here. It says it will have all the powers of a court of appeal by section 427. 427 is like changing the finding of case, or court of session by this section. This is giving pardon to somebody, and the court of session would have same power as section 440 says, same power as far as practicable that section 442 provides to the High Court. Thank you.
Hi, I'm Chitwan Lalji, a PhD student of Health Economics under the supervision of Dr. Debayan Pakrashi from the Department of Humanities and Social Sciences, IIT Kanpur. In one of my essays, I'm interested in understanding the relationship between consumption of fruits and vegetables and various health indicators. Health indicators, both subjective and objective health indicators like mental health, self-assessed health, various measures of blood pressure and various measures of cholesterol. Measures of blood pressure like systolic and diastolic BP. You have your incidence of high BP, MAP and incidence of high MAP. And as far as cholesterol is concerned, I have tried to concentrate more on total cholesterol, good cholesterol and incidence of high cholesterol. Now before I go on to what have been my major contributions and various policy implications, I would like to briefly tell you about the policy initiatives of WHO and various countries. The WHO, that is the World Health Organization, it started with a campaign of 5 a day. That is, you should have 5 portions of fruits and vegetables per day. That would be approximately, you could say, 400 grams of fruits and vegetables. Now, a portion, before we go further, I'll just tell you what exactly is a portion. One portion is equivalent to a medium-sized apple, or one small glass of fruit juice, which is approximately 150 milliliters, and maybe 3 teaspoons of vegetables. So, the WHO went with a 5 a day campaign, which was further taken up by various countries. Countries like UK, Netherlands, Germany, Norway, they adopted the 5 a day policy, while some went for expansionary dietary policies like France, Australia, Canada, Denmark. So, for example, Australia, it went for 2+5 policy, in which it said that you should consume 2 portions of fruits and 5 portions of vegetables per day. And USA went for a policy of fruits and vegetables, more matters. That is, you must consume more and more fruits and vegetables. Now, irrespective of these expansionary dietary policies and dietary propagations, it has been found that only 28% of women and 25% of men, they actually meet the recommended dietary norms of 5 a day portion. So, the major contribution of my work is firstly to find an association between fruits and vegetables, whether there exists a relationship between fruits and vegetables and health indicators, and if they exist, whether due to heterogeneity in the data, so I will be doing it according to age, by gender and by your weight. So, apart from that, I will go for policy recommendations, in which I am basically studying how much fruits and vegetables matter. Apart from that, which type matters more. So, for that, I have taken data from the Health Survey of England. Health Survey of England is an annual survey which takes data, which conducts information regularly on demographic and socioeconomic characteristics. You have your lifestyle behaviors like an individual smokes or doesn't smoke, alcohol consumption, you have your sedentary and physical activities, and you have various health indicators also which have been collected. Before I go on to what exactly is my research, I would like to concentrate more on fruits and vegetables, like what kind of questions were asked in the survey. Questions like, what kind of fresh fruit do you eat? Did you eat any dried fruit yesterday? Don't count dried fruits in cereals, cakes. Apart from that, for vegetables, they asked how many tablespoons of vegetables did you eat yesterday? So, approximately after this whole survey was conducted, data was converted into portions of fruits, and like for example, 3 tablespoons of vegetables is equivalent to 1 portion. So, data was converted and provided to the users, that is us, from the UK Data Health Survey. So, the major contributions of my paper is that I found a strong negative association between intake of fruits and self-assessed health, then various measures of blood pressure like mean arterial pressure, high blood pressure, systolic and diastolic BP, and your total cholesterol. Apart from that, I have found a strong positive association between consumption of vegetables and good cholesterol. So, it is recommended in a way that if you want to control your blood pressure, you must consume more and more fruits. And as far as vegetables are concerned, they impact your good cholesterol. Apart from that, I went in for a falsification test. A falsification test is basically conducted to know whether the model that you have adopted and the conclusions that you are drawing are not spurious. So, if a falsification test is done to know, in a way it is tested by seeing an indicator, a health indicator which is not being impacted by your consumption of fruits and vegetables, and then we see whether there is significant result or not. If there is no significant result, that means your model is good and your results are non-spurious. So what we did is, for falsification test, we took ear complaints and infectious diseases. Now ear complaints, like if you are deaf since birth or you have some kind of imbalance, body imbalance, that is not being impacted by your consumption of fruits and vegetables, and we did find insignificant results. Apart from that, infectious diseases like HIV, AIDS, etc., we found similar insignificant results, indicating that our results are not non-spurious. Apart from that, we went, since there was a lot of heterogeneity in the data, like by gender, by age and by weight, we did the regression analysis. We found results which stated that as far as fruits are concerned, it impacts a male's health more than a female's health. So it is basically said a man should consume more fruits to impact his health, whereas as far as vegetables are concerned, they impact a woman's health more. But this has been only seen as far as cholesterol is concerned, the various measures of cholesterol like total cholesterol, good cholesterol and your incidence of getting high cholesterol. Now after this, we went in for a policy implication, and in the policy implication we tried to find two policy implications: what matters and exactly how much portion matters. So as far as how much portion matters, we have found that on an average 5 or more portions of fruits impact your overall health, that is your self-assessed health, your MAP, your incidence of high MAP and incidence of high BP. But if you want to have a good mental health, so you can optimize your mental health by consuming 3 or 4 portions of fruits as well. And similarly, as far as self-assessed health and total cholesterol is concerned, an individual must consume 4 to 5 portions to optimally have the impact of consumption of fruits. Apart from that, vegetables have had a very little impact on your health. It only impacts your incidence of getting high MAP and high BP, and it's seen that only it impacts when you consume 5 or more portions of fruits. So an optimum consumption of 5 or more portions of fruits and vegetables are recommended, but fruits have a more impact on your overall health, on various measures like self-assessed health, mental health, your various measures of blood pressure and various cholesterol levels. Another thing that we find is which type of fruit matters. It has been seen that all size fruits, they impact your self-assessed health, your systolic and diastolic blood pressure, your mean arterial pressure, your high BP and incidence of getting high MAP and high cholesterol. But we find that as far as frozen fruits or canned fruits are concerned, they help in regulating your incidence of getting high MAP or high BP, but it has a trade-off. That means there is something negative happening. It reduces the good cholesterol in your body. Apart from this, if you have an incidence of getting high cholesterol, it is recommended that you must consume fruit juices because it has a impact in reducing your probability of getting high cholesterol. And dried fruits, they impact your self-assessed health. As far as vegetables are concerned, very little impact has been seen. It has only been seen in case of portion of salads and its association with self-assessed health. Another thing that they have seen is vegetables in composite, they have an association with good cholesterol. So overall, my research basically says that there is an association between consumption of fruits and vegetables and various health indicators, and it is highly recommended that an individual, in order to be healthy, must consume 5 or more portions of fruits and 5 or more portions of vegetables per day, but fruits have a more impact on your overall health. Apart from that, all size fruits, they have a better impact on your overall health, your mental health, various measures of blood pressure and cholesterol. So, thank you.